How's it going, everybody? In this video, I have an update for you on the Duncan v. Bonta case, also known as the California Magazine Ban case. So let's talk about this. But real quick, before we jump into this video, if you think that the California Magazine Ban needs to be removed, go ahead and hit that like button and subscribe. Also, I want to mention real quick that we are reaching the 2-year anniversary of this YouTube channel. First and foremost, I cannot thank you all enough for watching and subscribing to this channel and supporting me on what I do here in trying to promote the Second Amendment. Also, I want to mention, if you guys are not subscribed and you watch my videos, I would really appreciate if you did subscribe. I kind of had this goal of trying to reach 150,000 subscribers by the 2-year anniversary. We're quite a bit of ways still right now, but if you guys would consider subscribing, I would really appreciate that. And if you drop in the comment section down below, hey, I'm a new subscriber, I will comment back thanking you. So thank you guys for all your support and looking forward to making way more videos for you guys. So like I mentioned in the intro, I have a quick update for you guys on the Duncan v. Bonta case, also known as the Duncan v. Becerra case, or the California Magazine Ban case. Just a quick overview, this is a challenge to California's Penal Code 32310, which is a ban on the buying, selling, transportation, manufacture, import, etc. of any magazine that holds more than 10 rounds, and the state of California deems those types of magazines to be large capacity magazines. This is a case that started in the Southern District of California, and Judge Roger T. Benitez, the Saint Benitez himself, found that this law was indeed unconstitutional. During this period where he gave that order, this led to Freedom Week, where millions of magazines were purchased and actually imported into the state of California, and now a lot of us are in possession of those Freedom Week magazines. A 3-judge panel in the 9th Circuit also found that this law is unconstitutional, and then that decision was appealed and was sought for an en banc review by the 9th Circuit. The en banc panel has heard oral arguments on this case, and now we're simply just waiting for a decision, and that decision can take quite a while. But the update I have for you guys on this issue of Duncan v. Bonta or Duncan v. Becerra is that some supplemental letters have been submitted by plaintiff's side, the people who are fighting for our constitutional rights. They submitted a letter, a 28J letter, to the en banc panel in the 9th Circuit, pointing to additional precedent and actual recent decisions by the Supreme Court which support our position that this law is indeed unconstitutional. And these two cases that were recently decided by the Supreme Court is the American for Prosperity's Foundation v. Bonta, which we've talked about prior on this channel actually recently, and then also the Cedar Point Nursery v. Hassid decision by the Supreme Court. So the American for Prosperity's case, or the AFP case, involves whether or not the state of California could demand that charities and nonprofits in the state of California that solicited funds and received funds from donors, whether or not the state could actually demand unredacted information from those organizations, including the name and address of those donors. So this is a case that made its way up to the Supreme Court, and it involved core First Amendment issues, and also a lot of 2A advocacy groups also opposed this law in the state of California because the state of California was going to seek the unredacted information of donors in the state of California who support 2A rights and were donating money to those organizations, and essentially the state of California wanted to know who those donors were. Now, the AFP decision was actually a decision in the 9th Circuit, and the 9th Circuit held that California's requirement did not infringe on otherwise anonymous donors' rights to associate freely under the First Amendment. So essentially, the 9th Circuit did not find that this was a constitutional violation or a First Amendment violation. Well, when this went up to the Supreme Court did find that this was a First Amendment violation. It was a constitutional violation, and indeed found that the 9th Circuit was incorrect in their analysis. So why is this AFP decision important, and why is it being used as authority in the Duncan v. Becerra case, which deals with core Second Amendment issues and the issue of magazine bans? Well, this is coming directly from the letter. Americans for Prosperity confirms that California's ban on constitutionally protected magazines cannot survive any form of heightened scrutiny the Supreme Court recognizes. So the AFP decision is being used as authority to show that no matter what level of scrutiny that the state of California is alleging and applying to this confiscatory retrospective magazine ban, it will not survive any of those types of scrutiny like the AFP decision did not when the Supreme Court looked at it. Also in this letter, it states that a flat and confiscatory ban is the very antithesis of narrow tailoring. To uphold that ban thus would require this court to repeat the same error that the Supreme Court just corrected in the AFP case. So essentially, AFP is being used to say, 9th Circuit, you've used this type of analysis before to try to uphold what the state of California was doing in this whole donor issue. The Supreme Court rejected that analysis in AFP, and here you cannot use that same analysis. If you do, and this makes it to the Supreme Court, they will reject your analysis again. But a lot of you guys are very familiar that the Ninth Circuit is not two-way friendly, and a lot of times they do have their decisions reversed by the Supreme Court. They are one of the most overturned circuits in the entire US, so this may not be super persuasive, but it is authority pointing to the fact that the Ninth Circuit recently used this type of authority, used this type of analysis in a different type of decision, went to the Supreme Court, was overturned, and now the whole point is if you use that type of analysis again here in this case, it could be overturned as well. The other case that is being submitted to the Ninth Circuit is the Cedar Point Nursery v. Hassid case. And this is all involving the issue of the whole takings clause when it comes to California's magazine ban. So this is kind of one of those issues that's been one of the supplemental issues in all these arguments. It's the fact that the state of California has a retrospective and a confiscatory ban on these magazines that hold more than 10 rounds. They are demanding that people either turn in these magazines, destroy them, modify them, or move them out of the state of California. And one of the arguments that's being made is that that is a takings because the state of California is not compensating people for the destruction of their magazines or them having to turn them over to law enforcement agencies. The plaintiffs in their letter pointed to the Cedar Point decision, stating that the court, being the Supreme Court, reversed a decision of this court, being the Ninth Circuit, undervaluing property rights and held that a California regulation requiring agricultural employers to open their property to union organizers for up to 3 hours per day violates the takings clause. They went on to state that the court held that the regulation was a per se physical taking because it affected a government authorized invasion of the property owner's right to exclude. They also then go on to state that the court also reiterated that the size of an appropriation bears only on the amount of compensation, and it emphasized that the intrusion need not be permanent or by the government itself. Any actual invasion of property as opposed to restrictions on use is a per se physical taking. Now, I know that was a whole bunch of legal mumbo jumbo, but what is kind of the main impact of the Cedar Point decision? Again, it goes to the whole takings issue, and it reinforces the fact that the California retrospective and confiscatory magazine ban does indeed violate the takings clause. And the fact that the state of California allows you to permanently alter and modify those magazines to only hold more than 10 rounds, that is still a permanent physical occupation / taking by the state of California. So as you can see, these two letters are really important when it comes to bolstering the position of us here in the state of California and for us gun owners here in the state of California, saying why the magazine ban that the state of California has is indeed unconstitutional. So the Cedar Point goes to the takings clause issue, and then the AFP goes to the type of analysis that should be used in this case and the type of analysis that has been recently rejected by the Supreme Court. So like I mentioned, we're likely still going to have to wait a while for the en banc panel to come up with their decision. Sometimes these take months, maybe even a year for something to come up. So definitely when that happens, I will let you guys know, but I just want to get you guys this information because this is interesting additional authority that has been submitted. We've talked about some of these cases in the past on this channel, and now those cases are being used to bolster the position that California's magazine ban is indeed unconstitutional. So if you guys have any questions, go ahead and comment down below and I'll try to answer to the best of my ability. Also, if you guys like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm. It helps to signal to YouTube that you guys see value in these videos, and then YouTube pushes it to more individuals who want to hear this type of two-way news. Even if you guys don't have anything you want to comment specifically, even just commenting, hey, I'm commenting to fuel the algorithm or to help fuel Al Gore's rhythm. A lot of you guys comment that. I really appreciate that. It really does help the channel. And you guys will likely see me if you do that type of comment. I'll be down there giving you a thumbs up, and thank you guys for that. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.